Ladies and gentlemen, this is William Keat of lawandalchemy.org and commonlawconstitution.org. Welcome. So this video is an attempt to address some of the furore that we've just been seeing recently on what is appearing to be a two-tiered justice system. And this is all wrapped up with the Sentencing Council and the sentencing guidelines, and some of you may have seen that, and how it creates a kind of an inequity, an inequitable situation. And I just wanted to do some commentary on this and then talk about how hidden behind this is obviously a much bigger issue. And I'm hinting already straight away that this is a distraction. But let's get into it anyway, because I want to put some information out there as to what this is all about, if you've kind of missed the detail. So this is all about the Sentencing Council. And the Sentencing Council, which is independent, obviously, it produces sentencing guidelines, which is an attempt, if you like, at consistency in justice. So they produce guidelines and they monitor how those guidelines are followed, and the point of it is to create consistency of justice all over the country and across time. You can see why they would want to do that. Now, these guidelines, they're actually followed by judges in a Crown Court, and they're followed by magistrates, obviously, in a magistrates court. And the previous guidelines were produced by the Council in 2017. And those are the ones that are current at the moment. And there's been a review for the last couple of years, and the new sentencing guidelines that they're going to be producing for, I think it's 1st of April 2025, coming into effect. The review was, which they do all the time, began in 2023. And people have got very hot under the collar about what these guidelines contain and the language that's changed within it. So the latest sentencing guidelines from the Council came up in Parliament and were criticised, and the Justice Secretary Shabana Mahmood had to defend that, or discuss it at least. She wasn't completely defending it at all, actually, but it came up in a debate or a Q&A session, or I'm not sure what exactly it was, but it was a debate certainly. And what emerged from that was that the new proposed guidelines, they've been in the pipeline for 2 years, and as I say, are going to come into effect on the 1st of April. The language has changed within it, and what seems to be quite contentious are the categories that are named within it. So let me just explain what's going on. So this is all about pre-sentence reports, which are known as PSRs. And a pre-sentence report is something that is compiled by the probation service when the court deems it necessary for the defendant. So the court will make a request in certain situations for a PSR from the probation service. And they can request one, order one. I think it's a request, really. But more importantly, the sentencing guidelines contains recommendations or guidance on when a PSR should be obtained. So it has an opinion, if you like, on when a PSR might be necessary. Yeah, and it outlines certain criteria, if you like, in certain situations. And generally, this is meant to be when the defendant is in a situation in which there is some sort of background context, some difficulties, there's a bit of a backstory to it, there's some vulnerabilities which the court might need to take into consideration, which is potentially, that's quite a good thing. There are good reasons sometimes for these things. Now, so that in a way, I suppose, is demonstrating, if you like, that the system is trying to be understanding. It's demonstrating a kind of a restorative nature to the justice system, and perhaps a desire for rehabilitation, all of those things. The problem is that as we get into it, you'll see where the problem has come about. Now, there are various types of conviction, of course. You can have different different types of conviction. You have a conditional discharge. You can have an absolute discharge. I don't want to go into all of these different things. You could have a fine. You could have, instead of those, you could have community orders of varying types, which might involve probation, unpaid work, sort of community service. It might require you to go on courses, for example, or there might be certain conditions like some kind of alcohol abstention, perhaps. And breaching those community orders, you can be brought back to court and then re-sentenced, or have the original offence sentence applied again. So, and then you might even have community order hours added, for example. So attenuated, that whole thing brought up on the table again. You've got to go back to court, possibly. And then, of course, you can have custodial sentences. Could be an immediate one, could be a suspended custodial sentence. There are all sorts of different things, outcomes that are possible. And so the point behind this is that the justice system is trying to, as I say, put in place a range of possible sentences. It's not always, sometimes there's the impression that we're, just people are being sent to prison. It's not the case necessarily at all. So the sentencing guidelines gives specific guidance on whether a PSR, so that's a pre-sentence report, just to remind you of what that is, should be requested from probation for a given situation. And the furore about it is because the existence of a report, because it might help you avoid a custodial sentence, gives you a bit of a backstory and an explanation as to your difficulties or whatever. If you have a PSR, you have a potential advantage there. So this feeds into whether the defendant should or shouldn't receive a custodial sentence, and consider the effects of prison on them. That's the point. Yeah. Now, the difficulty is that this favours certain categories because the guidelines only mention certain groups or cohorts of people. Now, that doesn't mean that the magistrates or judge might decide that they either don't need a pre-sentence report in a given situation, might say, no, we don't need it. But equally, it might be that if in the guidance, you're not in a category that it recommends that should be asked for a PSR, that doesn't necessarily mean the defence won't make the case that you should have one anyway. Yeah. So is this actually really serious? It's not that serious, but it is a point. Yeah, because what it's producing is a situation or a condition of inequity. There's no question. I'll get onto that a little bit more. But what are these cohorts and categories? Because that's the thing that's contentious. So let's just run through some of those. So that would include being at risk of a first custodial sentence. So these are the categories where it is explicitly recommended that you should have a PSR in court. Yeah. So if you're at risk of a first custodial sentence, or your potential sentence is going to be 2 years or less. Why is that? Because there's been, I think, some research done on the fact that shorter sentences maybe do more harm than good. Yeah. So that's an example of why we're being careful here. Yeah. Young adults between 20 and 25. Female, because I think there's been, I can be corrected if I'm wrong, but I think there's been some research done that women are potentially, there's the potential for more damage done by a custodial sentence. Frankly, I'm not surprised, but now this is particularly contentious. Ethnic, cultural, faith communities are included on that as well. And you can see what that's implying. Pregnant, postnatal, if you are a sole or primary care of a relative, you can see where some of these are in a way quite common sense and it's quite difficult, because if you're going to send them to prison, look at the chaos that's going to ensue around you for others as well. These are the sorts of things that they're trying to sort of take into account. Whether you've disclosed transgender status, whether you have addiction, whether you have mental illness of some sort, are you at risk of victim, or you've been a victim of abuse, and it mentions things like modern slavery, grooming, all kinds of things. Yeah, but it doesn't mean that a PSR can still be necessary otherwise. Yeah, that's an important point. So is the excitement over this justified? Do people have a point? Yes and no. So yes, it does generate a condition of inequity, and I've said that. But frankly, you have that everywhere, all over, because actually just legislation itself creates a condition of inequity. But it doesn't say that you might not request a PSR for, say, a white Christian man. You might still do that. But yeah, I get the point. What people are saying is it's not on the list of requirements, which is interesting. I take that point. The case can be made, however, as I've said. So, so is Will making excuses for this? No, because it does, as I say, create a condition of inequity, meaning we're not equal before the law there. Yeah, and that's a problem, and I get that. But it's hiding and distracting people from the bigger issue. So we've got a massive furore about this. And that whole excitement that is being, and it is everywhere, all over social media, by the way, is masking a more serious issue. And you know where I'm going to go with this. Yeah, this is all to do with the backlog and the problems in the courts that, the whole Brian Levison review, because, this is an attack potentially on trial by jury. That's the bigger issue. Yeah, in the authentic constitutional rule of law, all of this and the above and everything I've talked about falls under the authority of the jury, which is, if you like, the safest tribunal that is most in line with equity, which is what we've just been talking about. And what was interesting in the very same debate that the Justice Secretary was talking about this, in that very same debate in which the sentencing guidance that I've just talked about was discussed, she was also making further encouraging remarks for the further erosion of trial by jury. And people have completely missed it. So this is the point, right? Is that we're getting distracted and taken off and, getting all flustered about, things that they're actually just effects. They're not the causes. Yeah. So what was she hinting at? And in fact, I'll quote, "For that reason, this is the Justice Secretary, I have asked Sir Brian to consider the case for reclassifying some less serious offences, whether magistrates' sentencing powers are sufficient, and the case for a new court to sit between the Magistrates' Court and the Crown Court. His recommendations will come later this spring." So let's just think about that. Downgraded to summary only. So that's taking potentially cases that can be heard in the Crown Court through either way, because those are the ones where you can elect for summary or go to Crown Court. And we're basically hinting at the idea that some of those offences will now get heard in the Magistrates' Court. Yeah. So, and by the way, there's another suggestion here. She was also suggesting perhaps and hinting at the idea that the either way aspect of an either way offence, where you can choose whether you go to the Crown Court or not at the moment, can be decided upon by the magistrate themselves. So in other words, the either way element is not your decision anymore. It gets decided by the magistrate. So it remains either way, but it might not be your decision anymore as the defendant. Yeah, this, that would be some potentially quite serious offences. So sentencing under the jury, right? Remember that under the proper constitution, when it's acting authentically, we would be in charge of sentencing it through the jury anyway. So all of the above is dealt with through that. Yeah, except that the caveat, of course, is that the state shouldn't go beyond the jury's decision. It can't be worse. Yeah, that's an important point. So people can't see this. They're kind of like having a go at, and moaning about having an influence, or rather I should say not being able to have an influence on the sentencing guidelines. But they're failing to see that juries themselves would have that power anyway if we restored the full constitutional condition. Yeah. So why aren't we supporting the jury trial? Why is this point not being made? Why is there no focus on this? We're not paying attention to the causes. Yeah. If you're not supporting jury trial at a time when you're potentially losing it, you are kind of going along with your enslavement. That's what's going on. Yeah, we're talking about the root causes, not focusing on effects. So the support of trial by jury is critical at this point when they're trying to remove it. So every week we're getting like a threat of crazy legislation. You know, we're getting a new bill in Parliament being proposed. But keep in mind that by correcting the constitutional principles, that, you know, every situation, the law is tested before a council of the people. That's how it works. So why aren't we paying attention to it? Yeah, and remember, of course, that the legislation that is most in need of annulment is often the summary-only offences, of which they're going to pile more into those as well. So that's going to potentially hide more legislation away from the jury powers of that check. Yeah. Now, the other thing, of course, is that the looming thing that people are not really noticing is this idea that we can change the constitution through legislation. We can do away with a cornerstone of our constitution simply by passing a piece of legislation. No, you can't do that. Yeah, and they're saying things like trial by jury. Yeah, no, it is important, but we reserve that for the most serious offences. Okay, well, who decides what the meaning of the word serious is there? See, it's a human decision. So now that's where you've got, if it becomes a matter of degree, you've got a problem. That's why it has to be absolute. Yeah, and thinking back to the last video I made, I talked about the Jamie Michael case, who was the soldier who, he made a video following the Southport attacks. But he, and he was, you know, he was prosecuted for that, but he was found not guilty by a jury in 17 minutes. Yeah, nobody's talking about this. I talked about in the last video about how we need to contact the Free Speech Union or Big Brother Watch or GB News or Talk Radio, or I can't remember who they all were. Black Belt Barrister was another one. I'm just not seeing anything out there. I'm not seeing anyone talking about this and correcting people and saying, no, you don't have the power and the authority to start legislating away pieces of our constitution. And it's not just a side bit either. It's like a central pillar. It's the absolute foundation of justice and the liberties of the people. Right? What's happening instead is that we're being manipulated. Yeah, we're being distracted. We're being taken into kind of like a civil war situation. You know, two-tier Kiev. I stand with Ukraine. Whatever it is. And what's happening is that the sort of the buzzwords are creating that distraction. You know, little short convenient buzzwords that are just repeated time and time again. It's basically mind programming. Yeah, safe and effective was another one, wasn't it? Yeah, that was just accepted by everybody. It's oversimplification. This is massive manipulation going on here. And we've got to remember also that maybe even some of these stories that are sort of getting us all worked up might not even be true. You know, perhaps they're only just being put out there just to get us worked up. We've got to be careful. Yeah, there was an instance the other day in the Daily Mail, might have been yesterday, I can't remember, where the Daily Mail shared an incident, a video of an incident that occurred, as it turns out, in 2017. Okay, and they themselves shared it in 2023, so they knew perfectly well. But it was being shared as if it was current. And what it was a video, I think, of a woman on a train, I think, being verbally abused. I can't remember exactly what it was. Okay, but somebody on the social media channel made the point and discovered that this was a like years old incident. Yeah, but this was probably an exercise in stirring things up by creating the impression that this was an outrageous current problem. Yeah, doing it by sort of bringing as many outrageous stories together simultaneously in order to create this sort of perfect storm of cultural threats in order to get us worked up. So that was the Daily Mail. And they were called out in that particular thread. And, you know, hundreds of us should probably just call the Daily Mail and say, why were you doing this? Yeah, nasty, divisive, manipulative and slippery behaviour. Because it's just all about you know, just agitation. So we need to be really careful that we don't fall into this trap of distraction. Yeah, this is about how we govern ourselves. This is about, you know, us being more spiritually mature. Okay, and talking about spiritual commentators out there should be on board with this. Yes, people are starting to ask, how do we envision a future system? Okay, good. It's a great question. Absolutely, we should be. But it's already been envisioned. It's already been done. The Constitution, the English Constitution, the original Constitution, is a framework for the very principles of the natural order or creation. It's the embodiment or the framework of individualism. It's the foundational principles of my rights end where another's begin. We've never quite achieved it as human beings, despite the Constitution framing it. Yeah, but there is no other way. It's not a choice. Anything else is control. Yeah, there's no other version, if you like, or alternative to a philosophy of minding your own business. Don't interfere. Don't remove another's choices. That's the ideology of individualism, or voluntarism, if you like. That's what the English Constitution frames. So, an alternative is to descend into kind of tribalism, which would be regressive. That would be going backwards. And that's what's happening right now. We're getting pulled into camps. We're getting pulled into extreme prejudicial positions. Yeah, instead of taking the responsible position of self-governance, understanding complexity, and being okay with nuance, and taking a genuinely moral path. Yeah, that's what the Constitution does for us. It's a framework for doing that. Yeah, people are get sort of allergic to the word constitution. Why? Because they automatically make the mistake that it forms a state. Well, no, it doesn't. That's the extraordinary thing about a legitimate constitution. The English Constitution was a legitimate one under natural law, meaning that it works in harmony with the natural order. It attempts to keep in place the Creator's intentions for man. It preserves rights as fundamental rights. How does it do that? It does it by the people governing themselves through the jury. There is no government in the normal sense of the word. Yeah, the English Constitution is a framework for natural justice if it's embodied authentically and understood properly. Yeah, and this is why anarchists, frankly, you need to get a grip and come on board and support this. Yeah, why are you ignoring this? There are many anarchists out there who understand and support the principle of trial by jury. In fact, many of you guys, anarchists, get this best of all, but you're ignoring this. You can't go from big state to no state in one go. There will always be a transitionary phase. Yeah, the country that governing itself through the people's own court of conscience is the embodiment of responsibility. That leads to healing due to that self-reflective element, the practice of exercising your moral compass. It's a win-win situation. Why would you not support it? That's what it creates. Complete win-win. Why? Because we get to do two things in particular. We get to put the government back in its box. Why? Because the people are governing in that situation. And we get to raise our own consciousness by exercising conscience, common sense, reason and logic. And that leads to the evolution of man and the embodiment of true sovereignty. So let's stop focusing on effects and getting distracted and being pulled into things that matter less at the expense of the critical. And then we'll make some progress. Hope you found that useful. Cheers for now.